Welcome back to the deep dive. So today, we're doing something a little different.
Yeah, a bit of departure for us.
Instead of the usual high-level research papers or geopolitical trends, we're diving deep into a consumer-facing product.
A legal strategy guide.
Exactly. It's marketed as a blueprint for individuals who are fighting workplace discrimination. And this isn't, some dry academic text. It's framed as a ready-made roadmap.
For practical impact.
Right. So our mission today is to unpack the core concepts this guide uses. It's all about how to translate that raw feeling of injustice.
What they call organic momentum. I love that phrase.
Me too. How to turn that into disciplined, actionable, legal knowledge, because really they're selling the confidence to fight back.
And that framing is so crucial. It speaks directly to the target audience.
Which is?
We're talking about litigants in person. Basically, people representing themselves in a legal fight.
Often against a whole company's HR and legal team.
Exactly. They're fighting solo, so they don't have the structure, they don't have the confidence, they don't know the right words to use. What's so fascinating about this source material is how it addresses that vulnerability head on.
How so?
It recognizes that a legal battle is, well, it's a mix of emotional conviction and really cold procedural mechanics.
And the blueprint is the bridge between them.
It's the bridge. It gives you the legal scaffolding, so your personal story doesn't just collapse under all that procedural pressure.
Which is what usually happens to people fighting alone.
All the time.
I appreciate that context. It really clarifies the purpose here. So let's get into it. The structure starts with a really accessible entry point.
The story and strategy bundle.
Yes, which retails for about £12.99, an introductory price.
Hmm.
And the product itself is called the Discrimination Blueprint, How to Fight Standard Procedure.
The title says it all.
It really does. And the genius of it is that the legal instruction isn't just a dry document. It's woven into a companion story.
The Elara Chronicles.
Exactly. It's a narrative designed to create that instant aha moment, for anyone who's been unfairly denied something at work. So the core scenario is, well, it's simple, but really powerful. It's about a woman named Elara who needs noise-canceling headphones. A reasonable adjustment.
A very standard request.
And she's denied. The reason? Standard procedure. Just bureaucracy, forms, delays.
But then you have her colleague, Ben.
Right. Ben.
And Ben needs a standing desk, also an accommodation. But for him, it's instant, seamless. No procedure, no fuss.
Just a quick manager approval. Okay, let's unpack this. That tiny disparity is everything, isn't it?
It's the entire foundation. That juxtaposition of Elara's denial and Ben's easy approval is what turns a vague feeling of being treated unfairly into a legitimate legal claim.
Ah, so the blueprint uses that to hit the first major legal hurdle.
Precisely. Proving less favorable treatment. The source material is very direct about this. It says, the moment a person with a protected characteristic,
like Elara with her disability,
it is treated worse than a comparable person without that characteristic. Like Ben, the treatment is illegal, even if the company just says, oh, it's just our policy.
So it weaponizes the details of corporate red tape. The rejection email isn't just a rejection anymore.
It's evidence. It proves differential treatment. And the whole point of the Chronicles is to show the user how to visualize that journey, from that first email all the way to a win at the tribunal.
That visualization of success must be so important for morale.
It's critical. It gives you the emotional fuel to get through the technical stuff.
Okay, so the story provides the momentum. Now, the blueprint has to deliver the actual legal strategy. What are the key legal concepts it breaks down for someone fighting alone?
This is where it really earns the name blueprint. It boils down some very complex law into three core arguments that you absolutely have to make.
And the first one we've basically touched on.
The comparator. The guide is adamant about this. It's non-negotiable. You can't have a successful claim without finding a relevant Ben.
And that sounds like the hardest part for someone on their own. I mean, you can't just demand the company's record.
You can't. And that's the genius of the methodology. It forces you to think like a detective. It doesn't just say, find Ben.
It prompts you.
It prompts you to look at past actions, departmental habits, even times when policy was bent for someone else. You have to build a documented comparison that completely dismantles the employer's first line of defense.
Which is always, we treat everyone the same.
Always. And the litigant in person has to prove that statement is factually wrong in their case.
Okay, so comparator is number one. What's the second critical point?
Actual knowledge. This is a huge one. It's an area where so many solo fighters fail.
Meaning what exactly?
You have to prove, beyond any doubt, that the company, and that means this specific manager or HR person who made the decision, knew about your disability when they made that decision.
And I imagine they could just claim they forgot, or they never saw the email.
They try. Which is why the blueprint is so focused on the paper trail. An email to HR, a doctor's note, a meeting summary you sent.
You have to confirm they received it.
You have to confirm receipt and understanding. The story shows how Elara used documented emails before the denial to prove the company had undeniable actual knowledge. It turns a casual mention into concrete legal proof.
What's fascinating here is how it just demystifies these intimidating legal terms, comparator, actual knowledge. It turns them into a checklist.
Into organized, evidence-based objectives.
Yes, which leads to the third major argument.
The hostile environment. Now, it's really important to understand this one alongside less favorable treatment. Remember, less favorable treatment is about one specific act, the denial of the headphones.
A single event.
A single event. A hostile environment, on the other hand, is about a pattern. It's the daily drip of comments, of behaviors, of an atmosphere that is intimidating or degrading.
But it has to be linked to the protected characteristic, right?
It has to be linked, and it has to be serious enough to meet a legal test. It can't just be a generally unpleasant workplace.
So one is the specific denial, the other is the cumulative weight of it all. How does the blueprint advise you to weave those two together?
By documenting both strategically. The specific denial is your anchor. It's concrete. But the hostile environment argument provides the powerful damning context.
It's the why.
It's the why. The blueprint shows you how to catalog every microaggression, every ignored comment, anything that made the environment unbearable because of your disability. The combination of the two is what makes for a truly powerful claim.
That transition from theory to practice is key. We've talked about the blueprint, the theory. Let's shift to the actual tools.
The Battlepack.
The Battlepack tools. Here's where it gets really interesting because this is where it becomes operational. Let's start with the comparator worksheet.
This is a brilliant tool. It's basically a forensic worksheet disguised as a simple table.
How does it work?
It forces you to get specific, to move past saying they treat him better, to documenting how. It makes you identify your Ben and then map out the differences. Job role, time at the company, performance.
And the exact treatment you both received.
The exact treatment. It's essentially guiding the user to do the evidence gathering a solicitor would charge a fortune to do. It organizes facts so clearly that a tribunal can see the basis for the claim immediately.
That clarity is powerful. But I have to ask, is there a risk here? You're giving people legal language and templates without a lawyer to guide them.
That's a very valid concern. And the disclaimer is, it's robust. It makes it clear this is education, not legal advice.
But still.
But the strength of it is that it recognizes why most solo litigants lose. It's not because their claim is bad. It's because their arguments are disorganized and use the wrong language. The worksheet doesn't guarantee a win, but it ensures the foundation is solid.
It gets you in the door with a credible case.
It establishes the prima facie case, yes. The basic facts you need to even start the conversation.
Okay, so if the worksheet is for building your foundation, the other big tool sounds more like an offensive weapon, the standard procedure rebuttal template.
Oh, it's absolutely a preemptive strike. It's a very sophisticated pre-written letter you send to HR the second they use that shield. We denied you based on standard procedure.
And what does it do?
Well, companies love to hide behind vague policies or subjective ideas like manager's discretion to justify treating people differently.
Right.
This template is like a diplomatic missile. It's preloaded with the specific legal phrasing needed to challenge that subjectivity. It basically forces the employer to state a legitimate, non-discriminatory reason for their action on the record.
Wow.
If they can't, a court might just assume discrimination because there's no other logical justification.
That's a huge shift in leverage for one person.
Yep.
It changes the entire conversation from why were you denied to why did your procedure result in less favorable treatment and where is your proof it was applied equally to everyone, including Ben.
Exactly. It forces them to engage with the law, not just their internal handbook. And as the source material says over and over, the whole point is to help litigants in person organize your thoughts and present your facts clearly.
That structure is everything.
For the learner, that clarity is the single biggest advantage they can get.
Okay, let's circle back and sum up what we've learned from this deep dive. We've seen how a narrative, the Elara Chronicles, is used to ground these highly specific legal ideas, comparators, less favorable treatment, in a really relatable emotional story.
And then how the practical tools, the worksheets and templates, turn that emotion into documented, legally framed evidence.
So what does this all mean for you, the listener?
Well, it means that the confusion and the sheer frustration of being shut down by standard procedure can be transformed
Instantly.
into structured evidence just by knowing to document that differential treatment from the very first moment it happened.
That's absolutely right. And this brings us to a final provocative thought for you to consider.
The power of visualizing the end goal. If this blueprint walks the user through Elara's entire journey, from the rejection email to her victory at the tribunal, well, how critical is it for you, in any complex situation, not just legal ones, to start documenting your experience with that successful outcome already in mind?
So you're not just reacting, you're building a case from day one.
You're building towards a predetermined goal. This knowledge shows that clarity and foresight in how you document things aren't just good habits. They're a powerful strategic asset. You treat every email, every small denial, as a piece of evidence on a path to success. That way, your facts are ready long before the final battle even begins.
A really compelling thought on the power of framing your own narrative. That's it for this deep dive. We'll see you next time.